sorry, I don't understand.
Cuddy say can't hang.
Oh, stewardess, I speak jive.
Oh, good.
He said that he's in great pain and he wants to know if you can help him.
All right, would you tell him to just relax and I'll be back as soon as I can with some medicine.
Just hang loose, blood. She's gonna catch up on the rebound on the med side.
Hey, good morning, good afternoon, good evening, everybody. It is me, Legal Vices, and I am glad and happy and thrilled to have you here with me right now on this little old channel that I like to call Legal Vices because, you know, I'm clever. It is a wonderful day today. Everything's been going good, I hope, for everybody out there. If not, hey, I hope things do get better for you. But today we are talking about YNW Melly. It's another YNW Melly update. As you may be aware, the retrial is underway. They're in the process of selecting a new jury. The jury selection process is expected to go through the end of the year. The opening statements are scheduled to begin on January 8th of 2024. So we're still looking at 2 more months. And what they're doing is they're balancing their time between motions and selecting the jury. There is an absolute F-ton of motions out there. And we're going to be talking about a lot of those. We're going to be reviewing some of the court orders as this goes along. The judge is getting a little bit testy because these motions should have been done before trial started, but they're piling on motion after motion after motion. Both sides. It's not just one side. It's both sides doing this, and it's grating on the judge's nerves. But today there's 2 specific situations that I want to talk about. One is Detective Moretti, the lead detective in the matter. What's his status? What are the sides trying to do with regards to him? And the other issue is YNW Melly's mother. She's been accused of some wrongdoings in relation to this case. The new prosecutor, she wants Melly's mom as far away from these proceedings as possible. And so we're going to be looking at both of those situations here today, as well as some other little updates. God, there's just so much going on behind the scenes with this trial. It's going to keep us busy all the way through the end of jury selection, I believe. And then we'll start the new year off with the retrial of YNW Melly. So before we dive into it, let's take a little peek over here and do our normal housekeeping operations. First of all, we have our like and subscribe poll set up. So the 132 of you that are here now, there's nearly 100 likes. So that's a pretty darn good ratio, but still there's like 40 of you that haven't done your job. So get on down there, hit that like button while we're doing this. But today's poll is a little interesting, I guess. It's a throwaway poll like we always do, but I do want to hear your opinions on this. And also make sure you hit that like and subscribe button because YouTube is purging me again. We've lost about 130 subscribers in the last couple of weeks because YouTube is being YouTubey. So double check, make sure you're still subscribed. No big deal, not making a big stink out of it. We got plenty to lose. But please, if you haven't subscribed, do me that little solid and get down there, smash the subscribe button. And if you are subscribed or think you're subscribed, just double check, please. And then take our like and subscribe poll. See, we've only got 108 likes, but 121 votes. That means some of you have voted without taking the like and subscribe button thingy down there. So do that. What is the problem with the YNW Melly case? We're 5 years into this. 5 years and like 1 month. We're 5 years into this. So why don't we have a verdict at this point? Well, I got 4 options. There's a lot of options, but I've put 4 down here just for the sake of the poll. So what is the problem in the YNW Melly case? Your first choice is what problem? There is no problem. Which I guess just means you think everything's going hunky-dory in the way it should. Your second choice is the big problem is an innocent man is being charged. Your third choice I've put up is The problem is prosecutorial and police misconduct. And your fourth and final choice in this poll, there's only four, you can only have four options, is it's taking too long, but it will be okay. So maybe a little delay thing there. We'll check back in a little while at what kind of the natural break between the two stories I've got, well, two updates I've got. We'll check back and see how things are going with the poll. We got 167 people are starting to pour in. Let me mute my phone here. Let me mute the old phone so we don't get interrupted by noisemakers during all of this. Oh, let's see. Patrick Hemkin says, sometimes I think Smelly made poor decisions in his life. No question about that. Poor decisions were made. Was one of those poor decisions the decision to murder two of his very best lifelong childhood friends? Well, I guess that's what we're getting here for. And people are talking about wolf spiders and black widow spiders and yikes, brown recluse spiders. No, let's keep spiders out of the stream. Spiders have no place in this stream. All right. Well, Leafy Fifi Foo says guilty, but too many F-ups to prove it. It's things are getting more difficult for the prosecution, definitely. They're doing the best they can. They're burying the defense in motions, but to be fair, the defense is also burying the prosecution in their own motions to dismiss people, to subpoena other people, to take depositions of other people, to suppress evidence. To limit evidence, not suppress, to limit evidence. So both sides are going full on with these motions. And that's kind of what I want to help us do here for the next few weeks while we go through jury selections, to sort of help you unravel some of these motions and get us ready for the trial when it starts. So we'll do this. We'll give you kind of a general update. Then we'll look at one motion regarding Detective Moretti, and then we'll look at other motions involving YNW Melly's mom. And while we're doing that, super chats come in. We'll read them off. Doggos are Yoda, Strawberry's behind me. Yoda's wandering in a house somewhere. So if we get to Doggo Cam, if we unlock that achievement, it's ready to go. Anything else? Yeah, we'll just, again, it's not a huge presentation today, so we'll read the super chats if cough when cough they come in. All right, and with that, let's see, anybody got anything to say before we get going? Friendly reminder, you have at least 6 different types of mites on your face right now. No spiders. Fine, I'll move the other. I could have a billion different types of mites on my face, and I wouldn't care anywhere near as much as I would care if there was even one simple, harmless little spider on my face. Bring on the mites. Just keep the larger ones away. Keep the larger spidery ones away. And Marv White kicking us off with the super chat. Cough. Thank you, Marv White, for that super generous, super chat. Thanks. That's got us started. So everyone follow. Well, oh my gosh, we have an early Valhalla sighting. Is there oh wow, look at that. We have an early Valhalla await sighting. Okay, folks, that's where we are right at the moment. So let's find out where we sit as far as the big picture goes. We know there's been a big giant motion from the defense. That was the motion to dismiss all charges against YNW Melly. The defense just wanted the judge to go, all right, fine, we're done, you all can leave. And the grounds for that was this prosecutorial misconduct and the improper, shall we say, illegal actions, allegedly, of the lead detective, Detective Moretti. He was the one that during the first trial swung me over to say, okay, The state, I think, has met their burden, and I would not be surprised if they came back with a guilty verdict. But we've recently come to find out that Detective Moretti may not be on the up and up. Shock, I know, that a police officer, a lead detective in a capital murder case may be less than ethical, less than, he may have less than average integrity. He may, in fact, be corrupt. Shocker, isn't it? In a nutshell, what he's been accused of or alleged to have done, and this is just by way of a reminder for those of you that know, and a little bit of a summary for those of you that aren't familiar with this. Recently, he was, I'm not sure, I actually don't even know if it was recent. I don't know when this search warrant was supposed to have been served on YNW Melly's mother. This was supposed to be a search warrant for her cell phone, for her mobile phone. And Detective Moretti, he also signed the affidavits for a very, very large number of other search warrants and evidence collection things that went on during the first trial. Well, for this particular search warrant, he didn't have jurisdiction to serve it. It was out of his jurisdiction. Now, for him to legally serve this, it would have had to have been with the assistance of a police officer or someone similar in the jurisdiction where YNW Melly's mother was at the time it was served. Well, at that point in time, I'm trying to remember who exactly was in the room. There was Detective Moretti, YNW Melly's mother, I believe YNW Melly's mother's lawyer, and a prosecutor. Not just any prosecutor. This is a prosecutor whose job it was to prosecute misconduct, illegal behaviors, and other things by police officers and prosecutors. She was in the room. And why that's significant is because Detective Moretti, who knew his search warrant was illegal unless he had someone in that jurisdiction with him, told a police officer who was outside of the room, who did not see this, who was not there, who did not assist with the execution of this search warrant on YNW Melly's mother. Nobody contests he was actually in the room. Everyone agrees he was not in the room when it was served. Detective Moretti told this other cop, if you're asked, if you know, just say you were in the room. Say you were in the room with me when this was done. And the officer allegedly responded, "I was there if you needed me to be." So yeah, if you needed me to be there in that room with you, then I was in that room with you. So Detective Moretti reportedly solicited this other officer to lie, to essentially falsify this affidavit regarding service of this search warrant against YNW Melly's mother. And when this search warrant was served, again, there is allegedly, reportedly, a little bit of excessive force used to wrestle the phone away from YNW Melly's mother. So the prosecution is arguing that not only was it an illegal search and seizure, it was based on the lead detective who is trying to get the defendant convicted of murder and put him to and assist the state in putting this kid to death. This officer solicited another officer to falsify an affidavit, to basically lie and help manufacture evidence against a person. So they want they want the charges thrown out. The defense does. So they filed this motion to dismiss. And all of this came to light. Why? Because this other prosecutor who was there overheard Detective Moretti solicit this other police officer to lie in the affidavit. She could have been a shady, scummy, corrupt, degenerate piece of crap prosecutor and hid this, went along with what Detective Moretti was saying and suggesting. She didn't. She reported him to Prosecutor Bradley, who was the lead prosecutor in the first trial. So the prosecutor that overheard this solicitation of the other police officer told the lead detective. Now, that's important also because the prosecution has an affirmative obligation. They have a legal duty to turn over any information that would prove or go to show or cast doubt on whether the defendant actually committed the crime. So if they have evidence saying that he wasn't there or didn't do it, they have to turn that over. If they have anything that suggests he may not have done it, they have to turn that over to the defense. The defense doesn't even have to ask for this. The prosecution has a legal duty to turn this over. Also, the prosecution has a duty to tell the prosecutor. The prosecutor has a duty to tell the defense release to the defense any evidence or information that also may call into question the credibility of their witnesses, of the prosecution's witnesses. Well, clearly, at least to me in my own little unfrozen caveman lawyer world, clearly, having your lead detective actively solicit another police officer to lie on an affidavit that would be used to gather and put forward evidence with the intention of getting a conviction for the defendant and sentence him to death. If you found out that was all based on a little tower of lies, that might call into question the credibility of your witness. That may raise the issue of whether or not he's a dirty cop. Well, he was also under an internal affairs investigation for this. Now, clearly, if the guy is under an internal affairs investigation, the defense would want to know that, because clearly if your guy is being investigated for internal affairs accusations or violations, that might go to his credibility as a witness. Well, it turns out that internal affairs investigation was shelved. It was put aside. It was just set there and no findings were made. Why do I think that was done? Pure speculation on my part. Pure speculation on my part says, well, our police department has this guy who is undergoing an internal affairs investigation. The prosecution has a duty to tell the defense about this this internal affairs investigation, because it calls into question this guy's credibility. If his credibility gets called into question, then that would discredit him as a witness, and as the lead investigator, this entire case may come crumbling down around us, and this guy that we want to get convicted and put to death may go free. So how do we avoid this problem? let's not do the internal affairs investigation, or let's wrap it up right now so that he's no longer under an internal affairs investigation and the prosecution wouldn't have anything to say about that to the defense. I think they shelved this, put it aside, suspended it, ended it early, whatever they did. I think they did it so that it would absolve, it would eliminate this problem for the prosecution and absolve their duty to tell the defense that the prosecution's star witness is under an internal affairs investigation. So you put all of these things together. It gets even better for those of you that don't know. It gets even better because, as I said, the good prosecutor that reported Detective Moretti's actions to Prosecutor Bradley, she did that months before the first trial. So, what did Prosecutor Bradley do? Did she go to the defense and say, "We've got problems with our star witness. This is what he did"? No, she did nothing. She mentioned it, she says, to her superiors in the office, in the prosecutor's office. They did nothing, didn't turn it over, didn't tell the defense anything. So for all these reasons, the defense filed a motion to have all the charges dismissed. Just dismiss the charges against Melly for these violations of turning over evidence, for all the corruption, everything that was going on. Just dismiss the charges and let him walk. The judge seriously considered this. It was not a foregone conclusion. Because the defense was, they were arguing a cover-up in the prosecutor's office. They were arguing misconduct from the prosecution witness, obviously, from the prosecutor, from the prosecution's main witness, Detective Moretti, et cetera, et cetera. They were making all of these allegations, and they wanted Bradley, the head prosecutor, the lead prosecutor, they wanted her off the case because they're going to call her as a witness during the retrial, because she witnessed the illegal conduct, allegedly, of Detective Moretti. So she, the lead prosecutor in the first trial, is reportedly going to be called by the defense as a hostile witness to discredit the lead investigator. That's where we left this when they made this motion to dismiss the charges and also a separate motion banking on the supposition that the charges would not be dismissed. They also filed a motion to have everybody in the prosecutor's office removed, which is going to be the subject of probably the next Melly update we do. But the important thing was this main motion to dismiss the case. The judge took it under advisement. The judge thought about it for, legitimately a long time. And then he made his ruling. So let's look at this ruling here. Well, the judge finds no cover-up. Let me embiggen this here. From the Sun Sentinel. The judge finds no cover-up in YNW Melly murder prosecution. So what does that mean? Deep into jury selection. In the retrial of Jamel YNW Melly, Demons on 2 counts of first-degree murder as Broward judge issued a formal ruling Wednesday, and this was a couple of weeks ago, October 25th, he issued a formal ruling Wednesday denying a defense motion to dismiss the case. He did, and I thought that if he would have dismissed it, I would have understood it, but I was not expecting it. I fully expected this to come down, and I mentioned that in previous streams as well. The ruling by Broward Circuit Judge John J. Murphy. Okay, let's back up. Sorry here. Denying a defense motion to dismiss the case and clearing the Broward State Attorney's Office of deliberately withholding key information from the defense. Not necessarily the lead prosecutor, just the office itself. There was no office-wide cover-up, is what the judge is going to say. The ruling by Broward Circuit Judge John J. Murphy caps months of legal disputes about what prosecutors knew about alleged witness misconduct, when they knew it, and what they did about it. The evidence does not show that Broward State Attorney Harold Pryor, he's sort of like the state's attorney general, I guess, for that county. So I guess it'd be like the district attorney is that's the word I was looking for. They call him the state's attorney for that county in Florida. So Broward State Attorney Harold Pryor, or deputies Regina Falk and Christopher Killoran, engaged in a cover-up. So the evidence does not show that those people engaged in a cover-up, blocking defense lawyers from learning that another prosecutor, Michelle Boutros, she's the good one. She's the one that reported it. She was the one that ratted Moretti out, had accused the lead detective on the case of asking Broward deputy to lie about the execution of a related search warrant. The lead prosecutor in the case, Christine Bradley, was removed by the judge earlier this month for failing to tell defense lawyers about Boutros' allegations before Demon's first trial early this year. Without finding that Bradley did anything improper, Murphy said the allegations of prosecutorial misconduct against her do not extend to her superiors at the state's attorney's office. At worst, Murphy said in his decision, a violation of the state's obligation to inform the defense about misconduct allegations would have resulted in a new trial, which Demons is getting anyway, because the jury in his last trial failed to reach a unanimous verdict. That's what I said was going to happen in this. I called it a long time ago when this first reared its head back in September. I called and I said, that, the remedy is a new trial. If this would have happened during the previous trial, I think the charges, if they would have found out about this and if it would have been brought up in the previous trial, I believe there would have been a mistrial with prejudice and Melly would have been a free man. I also think that if it would have come up during the retrial, and a trial starts when you do a preliminary swearing in of potential jurors there in Florida. So that was October 8th. So if this would have come after October 8th, when they got all the jurors together and said, do you promise to be good and honest during the jury selection process? From that point, that's when jeopardy attaches. And if they would have found out about this after that point, I think there's a very good argument to be made that the case should be dismissed again with prejudice and he should have walked free. Unfortunately, this came to light in this gap between the two trials. And of course, Strawberry has put that bone of hers in that sweet spot where it makes all the noise. So this all came to light in this sweet spot between the end of the first trial and the beginning of the second trial. And so the remedy, as the judge said, would be a new trial, and that's what he's getting. So let's continue with the new trial. This is what I thought would happen. Defense lawyers Jamie Benjamin and Daniel Aronson said they were crippled in their effort to prove further prosecutorial misconduct because Murphy did not allow them to formally question Pryor and his two deputies. Again, that's going to be one of the things we're going to talk about in the next update. Jury selection in Demon's retrial is still in its first phase, with potential panelists being ruled out if they cannot devote the time needed to hear the case. The second phase of jury selection will determine whether they can be unbiased in hearing the case and, if necessary, imposing the death penalty. Demons is accused of gunning down fellow rapper Christopher YNW Juvie Thomas and Anthony YNW Sack Chaser Williams 2 years ago after a late night recording session in 2018. Someone can't do math here at the Sun Sentinel. 2018 was not 2 years ago. That would be 5 years ago. His first trial ended in a hung jury in July. So that's what happened. The judge says, sorry, there's not going to be a dismissal of the charges against YNW Melly. We're going forward. So that's the big blanket overview there of what happened. So trial's going forward. Trial's been moving forward since that time, since the judge says there's no dismissal. Motions have been flooding in, and we're going to be looking at, as I said, 2 batches of those motions here today. We do have a few things to get through here. Easy 007 with the 2 pounds. This trial has been a crazy ride. Thank you for covering it. Hey, that's what I'm here for. I'm here to cover the trial. Bridget, who's been a member for 4 months, says, "Why was that prosecutor there? Little confused. I don't know why she was in the room, but she just happened to be there. I don't know why. I don't know why the good prosecutor was in the room, but she was, yeah, and that's where we find ourselves. And I've got to go take that bone away from Strawberry. Hang on real tight here. I'm just going to turn the camera off and stretch over here. Hey, sorry about this. You can't do that, little bonehead. Now she hates me. Straubs, you can't do that, huh? You can't do that, little girl. Oh, poor little Strawberry. Yeah, she definitely contributes to the live stream. It's just she just knows that literally there's a space this wide in my house where this bone gets wedged between the sliding doors for the veranda. And it's made of hollow aluminum, so it just echoes and rattles. And she just knows to put the bone there. So there we go. Give Strawberry her bone, her chat, and mods revolt. Well, you can't hear me. It just makes too much noise. But she'll get it afterwards. Don't worry. Okay, so let's see where we're going here. Just checking back through chat. 100 people have not hit the like button. Oh, come on, people, hit that like button. We got 300 people here and 197 like. Wow, you're right. Exactly 102 people have not hit that like and subscribe button. Poll, folks, just we're going to look at the poll here. Just take a quick little break. Reach down there, smash that like button while we do this. You've watched it for more than a couple of seconds, so you had to have liked something. And then I can stop talking about it. All right, the poll again, I said we review this after each one of these stages that we go through tonight. What do you think the problem is with the YNW Melly case? 5% of you, it used to be 3, and now we're up to 5% say an innocent man has been charged. 5% of you think he is innocent of the charges against him. 12% of you say it's just taking too long, but it will be okay. 14% of you have said the problem with the case is there is no problem. What problem? There is no problem. Everything is going great. Everything is going the way it should be. The right people are being charged. Everything's happening procedurally the way it should. 69%, nearly 70% of you say that the problem with the YNW Melly case is prosecutorial and police misconduct. Can't argue with that. That's my answer. That's my answer to that question. So I think we're on the same wavelength as far as that goes. Okay. No bone, no peace. She'll get it. She's just happily licking my toes under the table, waiting for the Doggo Cam achievement to be unlocked. If that ever, it's been a while. This trial is crazy, D. Marie, and that's not the way. That's not the way trials should be. We shouldn't walk away from so many trials saying, "Wow, this trial is crazy." I mean, you can say, "Oh my God, there was some crazy stuff that came out in court today," or what this guy did was crazy, or what this person alleged was crazy. You can say there's the evidence in this case is insane. That is fine. That's understandable. But we look at this case. We look at the Murdoch case. We look at the Zachariah Anderson case. To some extent, the Rittenhouse case. But when you're actually looking and saying the trial itself is crazy, that's crazy. That's crazy that you would say the trial is crazy. It's not supposed to be that way. I mean, for example, tune in tomorrow because we're going to be doing the opening statements in another case that recently started in Texas. A little love triangle with two ladies that were in love with a bicyclist. One of them allegedly murdered him. The prosecutor in that case did a phenomenal opening. The defense, not so awesome, not so phenomenal. And that's a case where you go, oh my God, this defense lawyer's opening is crazy, but not the trial itself. It's frustrating. It's frustrating as a lawyer to have people say the trial's crazy, because that's not what justice is. Justice isn't about having a crazy trial. It's about having a normal trial with crazy allegations, crazy witnesses, crazy statements. And a lot of times you out there in chat ask, what's wrong with Florida? This is a Florida case. What's wrong with Florida? What's wrong with Wisconsin? What's wrong with Utah? What's wrong with Idaho? What's wrong with Texas? That they have all of these weird trials and all the people doing crazy things and all these problems with the courts. What's going on in these? It's not just those states. Why we're not talking about the crazy stuff that's happening in South Dakota? Why we're not talking about the crazy stuff that's going on in Oregon is because we're not seeing it. All of these trials that streamed are coming out of Florida, Wisconsin, Utah, Texas, where they're more open about what they show and what they broadcast, what they stream. It seems like we're seeing so much from these states because these are the states that are letting you see. You have to understand this is going on in every state. It's going on everywhere. This police misconduct doesn't just happen in Florida. It doesn't just happen in Texas. It doesn't just happen in Wisconsin. The prosecutorial problems, the problems with the judges don't just happen in Wisconsin. They don't just happen in Florida. They happen everywhere. We're just seeing it more because they're starting to open the courts to cameras. I know I've said this a million times. I think there should be cameras in every single court proceeding of any nature whatsoever, from the lowest of the traffic courts to the highest of the high courts, in the most series of crimes, except for sensitive cases involving children and things like that. Where you wouldn't want to put children in those types of live streams. But I mean, just the normal horrible cases should be there. The especially children and maybe some of the essay-based crimes shouldn't be live streamed, but generally the vast majority of every single case in every single court should be live streamed, available online, or something. Transparency. Just as I think every single police officer in the universe should have a fully functioning, always on body cam. We need to see what's out there. Rose said she's a defense advocate. That's why she was there that day. No, the lawyer was not a defense advocate. She was a prosecutor. She was with the prosecutor's office. She just happened to be there. You can't really be a defense advocate and be there when it's good and be a prosecutor. Silent Rage 5, probably being one of the more honest people. Not gonna lie, didn't even read the poll question. I just clicked something to get rid of it. I understand. It's understandable. I may or may not have done that a few times. Oh, that's why you took her bone. You're a sick man, Daddy Vices. She'll get it back. She's just sitting here under the desk saying, hey, where's Doggo Cam? See, and now I'm being baited. Bunning Sensations is now trolling me. Jeff, but he has to prove he's innocent. Right, King Ginger? I'm not going to go on the rant. I'm not going to go on the defense. It doesn't have to prove shit rant. I'm just going to say, no. The defense doesn't have to prove anything. They don't have to say anything. They don't have to open their mouth. They don't have to put on a defense. It is the state that has to prove everything beyond a reasonable doubt, fairly, and in conformity with the Constitution. Valhalla waits. The more trials we watch, the more crazy we see. It seems pretty widespread. It's ubiquitous. It's everywhere. This stuff happens on the daily everywhere. We need to see it. We need to, when we go to the, so you thought I was going to go off on one of these, the defense doesn't have to prove innocence rants. I'm going off on the, when you go to the poll, like the county dog catcher, county clerk, we just check off these boxes on the ballots because we don't, if we happen to know the person, we check off their name. If we don't, and we're a Democrat, we usually check the Democrat. If we're a Republican, we check the Republican or whatever. But when you go in there and you're looking at electing a district attorney or a state's attorney in Florida's case, when you're going to elect these people next time, find out who they are. Look at their record. See what you can find about them online, because these are the people that are going to be prosecuting the bad guys, maybe some of the good guys, maybe you one of these days. If they're bad, if they have bad track records, if they've been accused of enough things, listen to what their opponents are saying. I mean, I'm more concerned with who is in a district attorney's office position than I am with who is one of the, the nameless, faceless people that's in a state assembly or a state, House or Senate or whatever. I think, the district attorney is a much, much more serious position because they have a lot of power. They decide who gets prosecuted and who doesn't. Get rid of the bad ones. The same with the judges. Look at the judges' rulings. Look how they're going. Hold the judges and the prosecutors accountable. Don't let the bad ones stay in office. Find out who they are. Find out their records and vote accordingly. Darth Hideous, long time nosy. How you been? Yeah, Jeff, what's wrong with massive, widespread political corruption? Well, nothing if you ask the widespread political corrupt people. They think it's just fine. See? There we go. Amanda Caesar. I did all the research I could before the trial started so I can form my own opinion, and I still don't know if I think he's guilty or not. But I do know the way this trial is going is not right. That's I'm not going to go down that big rant path either, but if you're going to convict someone, if you're going to try to take away their life, if you're going to put them to death or lock them in a little hole for the rest of their natural born life, you do it fairly. You do it properly. You do it in accordance with the Constitution. And we've got a few more chats going here. Jeff Moser with the $2. Crazy Arizona case with Mormon Samuel Bateman. I don't know who Mormon Samuel Bateman is. Don't know which case that is, but it's in Arizona. Probably is crazy. Tank Rat dropping 20 legal vices memberships. Dropping the big guns. If you're one of those 20 people that got that big gifted legal vices memberships, we have a membership stream coming up in the next week or so. We'll have just a chill members stream. Give Tank Rat a super special thanks for that. And Tank Rat has also been a member for 13 months of the Legal Vices Fallen Angels Mega God tier level. It says 1 year and a month in as a fallen angel. Too bad most of the time I catch you during my work time. Well, I'm glad you're here, Tank Rat. You are a huge supporter of the channel. Deeply, deeply appreciate it. And people give him the thanks if you got one of those Vices memberships. Oh, what are the new charges? Yeah, we'll get to the new charges too. That'll probably be 2 YNW Melly updates from now, but he and Bortland have been charged with 7 new crimes: tampering with witnesses. We'll read the briefs in there. We'll read the motions and whatnot, the charges, the arresting documents. We'll deep dive these 7 new charges against YNW Melly and YNW Portland. So that'll probably be two updates from now. Tankrat is definitely a patron saint of the legal vices. Thank you, patron saint. Samuel Bateman, crazy Arizona case, caught transporting multiple underage Mormon women in a U-Haul type trailer. Ooh, is he one? Are you sure it's a Mormon case, or is it one of the RLDS, the Jeffries guys that live down there on the border in the crazy weird little compounds? Oh, yes, Philip Martin. They are charged with tampering with witnesses, but the cop and prosecutor ain't. Yeah, cop and the prosecutor aren't being charged with anything. Of course not. They're probably gonna get promotions out of this, you know. Oh, we'll get there. Why? Who do you think took notes of the jurors and gave them? Yeah, when they arrested Bortland, they sort of kind of found a map of the jurors and where they were sitting and their descriptions. Not the greatest thing to be found, but yeah, we'll talk about those very, very soon. We'll fill up all of our suppositions and things at that point. Don't want to give too many spoilers for what's coming in the future. All right, let's see how we doing here. Righto, let's move on to the next little thing. We got caught up on all of the old super chats. We're about 90 away from unleashing Doggo Cam. Let's move on into the next story, shall we? How do we want to do this? Which one do we want to do first? I think we should look at the motion for Detective Mark Moretti, the lead detective. Because what I think is happening with Detective Moretti is, I mean, as I said, he was the lead detective in the case. He was responsible for a lot of the affidavits, a lot of the search warrants, a lot of the evidence gathering. He gave the star testimony for the prosecution in this case. Then all of these allegations came up, and the defense flat out said, when you put him on the stand in the retrial, we are calling the good prosecutor as a witness to discredit him. We're calling the bad prosecutor as a witness to impeach his credibility. And I think that because the prosecution knows what's on the table, they're trying to find a way to present their case without putting Detective Moretti back on the stand. I think they're going to be putting someone else who knows what Moretti did, knows the evidence that was gathered, and can get through their testimony, hopefully without being impeached like Moretti did. So I think they're trying to do an end run around their way, and they're planning on not bringing Detective Moretti back as the star witness. That's what I think they're doing. Why is that? Because of these motions that we're going to be talking about now. Let's bring this on up. Yes, this is the one we want. Philip Martin says, I've been here about 5 minutes. When I rewatch the first 45, is it going to make me mad? I don't think so. I think it'll be good. We're just kind of reporting the facts. We're not feeling particularly aggressive today. Righto. YNW Melly back in court for hearing ahead of double murder trial. This was the 2nd of November. This was November 2. Attorneys for Melly, whose real name is Jamel Demons, were asking for another chance to question the lead detective in the case. Prosecutors claim the defense doesn't have the right to question the detective again. Normally, when you depose someone, say the defense wants to depose the lead investigator, so hypothetically, normally you get one crack at it. You can't keep calling them back for more and more depositions. You get one chance at it. They had their one chance. They said they wanted another chance to question Detective Moretti, and that was denied. They've already made a motion to redepose him. That was denied, and then all of this stuff came up. All of this stuff came out, and so the defense filed a second motion to take the deposition of Detective Moretti. So attorney for Melly, whose real name is James Demons, were asking for another chance to question the lead detective in the case. Prosecutors claim the defense doesn't have the right to question the detective again. Rapper YNW Melly was back in a Broward County courtroom Thursday for a hearing ahead of his double murder retrial. Attorneys for Melly, whose real name is Jamel Demons, were asking for another chance to question the lead detective in the case. Prosecutors claim the defense doesn't have the right to question the detective again. I think we've heard that already. Judge John Murphy, who is overseeing the case, said he would rule on the motion later Thursday. He did not rule on the motion last Thursday. His decision is still pending. So the judge hasn't made his decision whether or not to allow Moretti to be redeposed yet. Jury selection in the retrial began last month and was expected to take several weeks. If you missed it at the beginning of the show, opening statements are scheduled to begin January 8th. So they're looking at least, hopefully, 2 more months to get the jury seated. So hopefully 2 more months, at least 2 more months is what's scheduled. If something magically happens and they seat the jury earlier, they might bump the trial date. They might move it forward. If it takes longer, they'll push it back, I guess. But they're expecting opening statements to begin January 8th. The retrial has been delayed after Murphy removed the lead prosecutor at the request of Melly's lawyers. Murphy granted the defense's motion to recuse prosecutor Christine Bradley in an abundance of caution after defense attorneys claimed prosecutors didn't reveal that the lead detective in the case had been previously accused of being willing to lie as he gathered evidence. And one thing, the good detective, the good prosecutor that ratted out Moretti did so in a very, very vocal way. She told other prosecutors, she told the superiors in the prosecutor's office that because of what she heard that day, under no circumstances would she ever prosecute another case that he was involved in. That's how adamant she was that this guy's a crooked cop. The judge didn't find that Bradley's integrity had been compromised, but agreed that she couldn't serve as a prosecutor on the case if the defense was planning to call her as a witness regarding the credibility of one of the investigators. Attorneys for Melly, whose legal name is Jamel Demons, had asked Murphy to remove the Broward State Attorney's Office from the case and potentially dismiss the case entirely. The request came after the Assistant State Attorney, Michelle Boutros, she's the good prosecutor again, who works for the Broward office, testified that she overheard the lead investigator in the case against Demons, Mark Moretti, ask a Broward County deputy to lie about being present when Moretti executed a search warrant outside his jurisdiction last October, forcibly seizing a phone from Demons' mother as part of a witness tampering investigation. Defense attorney Jamie Benjamin said that the information should have been turned over to the defense because they could have used it to discredit Moretti during Demons' recent murder trial, which ended in July with a hung jury. Prosecutors say the exchange between Moretti and the deputy was a joke. Yeah. They said, oh, when I asked him to lie about being there, oh, I was joking. He knew it was a joke. We all just knew it was a joke. You know, I wasn't seriously asking him to say he was in the room when I executed the search warrant just because it would have been illegal if he hadn't have been. No, that was all just a joke. Yeah. Prosecutors say the exchange between Moretti and the deputy was a joke, pointing to the fact that an attorney for Demon's mother was present when her phone was taken and would have known the deputy wasn't there. Demon's first murder trial ended with a 9-3 vote for conviction. Melly faces a possible death sentence if convicted of first-degree murder in the 2018 slayings of two childhood friends, Christopher YNW Juvie Thomas and Anthony YNW Sackchaser Williams. Their stage names all include YNW because they belong to the same hip-hop collective. It stands for Young New... No, it doesn't. No, it doesn't stand for Young New Wave. Or another phrase that includes a racial slur. Yes, that's what it stands for. It stands for Young N-Word World. Young N-Bomb World is what that stands. Not Young New Wave. Anyway, prosecutors say Melly, after a late-night recording session, shot Thomas and Williams inside an SUV, and he and Cortland YNW Bortland Henry then tried to make it look like a drive-by shooting. The 24-year-old rapper remains jailed without bond. Melly's biggest hit, Murder on My Mind, reached number 14 on the Billboard Hot 100 chart in 2019. Well, there she blows. Let's watch this little 3-minute.
South Florida rapper YNW Melly back in court again today.
Ahead of his double murder retrial, his attorneys want another chance to question the lead police detective in the case. NBC6's Marissa Bagg is live in Fort Lauderdale with today's court proceedings.
And again, we're going to hear some amazing court audio. And by amazing, I mean really, really bad.
Well, Jackie, the judge showing a little bit of concern today over the number of motions that still need to be handled, because depending on the day of the week, attorneys are either trying to pick their jury or they're arguing motions in front of the judge on this very complicated case.
You're coming at the 11th hour not knowing anything.
Attorneys took a break from jury selection in the second YNW Melly.
See, the judge is always looking like he's not really happy with the way things are going. I like this judge. I think this judge is an amazingly good judge, and he's not having a lot of this. Oh, good.
I love that.
Wait,
we
what?
called each
No! What's happening here? All right. Don't touch that button, eh? No, don't do that.
An adorable Prince William fan
That's
wasn't
funny.
afraid
All right.
to get up close.
Hello. There we go. Try again.
In court again today.
Ahead of his double murder retrial, his attorneys want another chance to question the lead police detective in the case. NBC6's Marissa Bagg is live in Fort Lauderdale with today's court proceedings.
Well, Jackie, the judge showing a little bit of concern today over the number of motions that still need to be handled, because depending on the day of the week, attorneys are either trying to pick their jury or they're arguing motions in front of the judge on this very complicated case.
All right, let's pick this up where we boomered off.
Not knowing anything.
Attorneys took a break from jury selection in the second YNW Melly
That
double murder
expression.
trial today to continue working through a laundry list of motions filed by both the state and the defense. The issue at hand today, whether the defense should be able to redepose or re-question the lead Miramar police detective on the case.
Right. So that's what the motion was about. And you're going to hear some of the arguments that they're making.
Ahead of his testimony in the second trial. The defense accuses Detective Moretti of
That's
wrongdoing while serving a search warrant on Melly's mother's phone last year, and they want to ask him about it directly.
I do not know what can show more corruption than an officer serving a search warrant when he knew he was out of his jurisdiction, physically taking something from a person which he did not have the right to do because he was outside of his jurisdiction. And then...
So that's one thing we're going to talk about here when you go through the motions, is that's that's kind of one thing that leads to being able to redepose someone if there's this type of corruption. He's saying, hey, how much more corrupt do you want than soliciting another police officer to lie about an affidavit, forcibly removing property from someone they had no authority to remove, while illegally serving an illegal search warrant against the person, and then trying to cover it up.
Asking another officer to commit perjury, that shows corruption.
But the state fired back, saying that the detective has been cleared through an internal affairs investigation, and any information they would collect from him would not be admissible in court.
There is no investigation. He has effectively been cleared by the Miramar Police Department. And what they now want to do is to pontificate or speculate that maybe some charges will come down the road, but there's just simply no evidence supporting that.
Melly, whose real name is Jamel Demons, is charged in the shooting deaths of 2 childhood friends in 2018. Jury selection for his second double murder trial is ongoing as attorneys and the judge sort out the dozens of motions filed. The judge appeared concerned today that the motions should have been handled before the official start of this second trial.
Don't want to rush in there, and it seems like there's a lot of motion and we'll rush through stuff.
And remember, the first double murder trial ended in a mistrial in July. This one had to start within 90 days of that happening, and they did meet that deadline despite the fact that a new prosecutor was assigned to the case because the previous one had been removed. Jury selection will begin on Monday. As far as the judge ruling on this latest motion, that has not yet happened today. Reporting live in downtown Fort Lauderdale, Marissa Bagg, NBC.
Okay, that's kind of the bird's eye view. Now let's take a look at the actual motions that are involved in bringing Moretti back, because they want, again, they've already made a motion once, the defense did, to redepose him, and the motion was denied. All of this shit blew up. All of this stuff came out, and the defense refiled. They didn't refile. They filed a new motion to have him redeposed, to have Moretti redeposed. So we'll look at the first motion from the defense to redepose our lovely, wonderful detective Moretti. We can embiggen this. How's that look over there? Let's see. Let's make it look pretty. That's too small, isn't it? All right. Let's just do what we normally do here. So bring this in and bigging it up. Boom. Right. Okay, here we go. In the Circuit Court of the 17th Judicial Circuit in and for Broward County, Florida, State of Florida versus Jamel Demons, defendant. Defendant's second motion for redeposition of Detective Mark Moretti. This is a barely a 2-page motion, which is interesting because the prosecution's response is a lot longer than this motion. Comes now the defendant, Jamel Demons, by and through the undersigned counsel, and files this, his second motion for the redeposition of Detective Mark Moretti, and in support thereof states the following. Again, this is what I was saying, that you get one crack at it normally. Florida Rule of Criminal Procedure 3.220H states that no person shall be deposed more than once except by the consent of the parties or by order of the court issued on good cause shown. So if either both sides have to agree to it or the court has to order it based on a really damn good reason. During the trial, Detective Moretti presented testimony regarding cell towers, the distance of the cell tower sector bands, interpreted cell phone data records, created Google exhibits, and further testified to the data generated from certain health applications. Now, in reviewing the testimony of Mark Moretti, there are serious discrepancies between Detective Moretti's testimony and the actual evidence provided by ASA Assistant State's Attorney Bradley. In addition to the above, it has been discovered that Detective Mark Moretti solicited a Broward Sheriff's Office deputy to commit perjury. Although Detective Moretti was previously deposed, it was only pertaining to his previous law enforcement investigations and reports, not the additional new areas referenced herein. The defendant not only has good cause for this request, but the redeposition of the detective is necessary for the preparation of the defendant's defense and pretrial motions. Matters relating to granting or limiting discovery rest with the sound discretion of the trial judge. So they're saying here, look, he solicited someone to commit perjury. He did all of these things. We think that's a really good cause. And as you saw in the news story there, they were saying, look, it's corruption. I mean, what more evidence of corruption do you need than a lead detective soliciting another person to perjure themselves in the illegal carrying out of a search warrant and possibly using excessive force? That's a really good reason. We need to talk to this guy again. We need to talk to him about those incidents before we go to trial again. And paragraph 7 here saying that whether or not to do this is up to the discretion of the trial judge. So wherefore the defendant Jamel Demons respectfully requests an order of this court allowing for the redeposition of Detective Mark Moretti and any other relief this court deems necessary and just. Certificate of service, it was served on everybody. So that's what they're saying. Those are their grounds. Those are their reasons why they need to redepose Detective Moretti. Now, the state has also submitted their response to that. Before we get there, we'll hold off on the chats, and I'm torn. All right, let's do this here. All right, Easy 007 with a £5 super chat. In the UK, we don't have video stream trials, only in person. So seeing US trials is eye-opening. I say crazy because it's easier to say as a whole. Understandable. You know, it's the process can seem pretty crazy, especially to those that don't live and aren't familiar with the U.S. jurisdiction and how things work here. But yeah, we shouldn't, I was speaking generally as well. We shouldn't be saying trials are crazy because they should be functioning normally, and this one isn't. Valhalla awaits member for 11 months. Thank you so much, Valhalla. Wow, 11 months already. Seems like only yesterday. It was yesterday, 11 months ago-ish. And King Ginger, Lamau, but the prosecutor said he lied one time, so let him go. So he's not guilty, despite the video and cell phone tower data. Ooh, they're saying the cell phone data, as we just read, isn't exactly what he said it was, and it contradicts what the prosecutor said it was. So they're saying, yeah, that cell phone tower data, we need to talk to him some more about that. I get lying is bad, but that doesn't negate his guilt. Well, we have yet to see whether or not he is guilty. Do I think he did it? Probably. Do I think that there are some very, very serious questions as to how that evidence was gathered? Yeah. And if that evidence gets thrown out, then you have to look at what is presented in court. You can know he's guilty. You can have such a firm opinion that you believe he's guilty, so firm, in fact, that you just know he's guilty. But you have to base that on the evidence that's presented in court. If something you know happened doesn't get into court, you can't consider that when determining whether or not he's guilty. So it's what the state is going to be able to submit as evidence and what the defense is going to be able to do to counter that or discredit that evidence, which means that even though he's guilty, even though you personally believe he's guilty, you may have to go with a not guilty verdict. Because of the problems with the prosecution and their actions and the way they do things and the way the investigation was conducted by the police. If he does walk free and you still think he's guilty, blame the prosecutor. Blame the police. Blame the detective. Don't blame the detective. Don't blame the defense lawyers. It's not their fault that the prosecution and police suck and are corrupt. And Jim Satala, member for 5 months. What the business? Free Melly Mel. He be what Rakim and DJ Smooth need to make it to the big time, lol. I bet hardly nobody even knows who those OGs are. Can't say as I do, but I can sure as hell tell you who Waylon Jennings is. King Ginger 33 is not a very complicated case at all. He murdered his two friends. It's going to be more difficult to prove that without your lead investigator testifying, though. Melly Demon's hair is gone. Now he was just tied back at the hearing. Don't panic. He's still got his hair. Okay. King Ginger 333 says he says something, but there we go. I agree. I 100% agree, Jeff. I just believe he's guilty is all. Like I said, I think I think he is too. But I'm going to have to base it on what evidence comes into court. And if I have to walk away from this saying not guilty, I'm going to blame the prosecutor and the specifically Bradley, the new lady. We'll see how she does. But if she drops the ball, I have to blame her. I have to blame Bradley. I have to blame Moretti. Those would be where I point the finger. Yep. Chico Mite, you have it exactly correct. I can personally think what I want, and the jurors can personally think whatever they want too. That MFer did this, but the jury has to be impartial and only consider the evidence and all that. I can just have a feeling if I want. Yep. And that goes right down to the jurors as well. The jurors can say, yeah, I think he probably did it, but the prosecution failed to prove he did it beyond a reasonable doubt. So yeah, you can. It's not one or the other. You don't have to think he did it and he has to be guilty or vice versa. You can think he did it, but the prosecution fucked up and didn't get the conviction. So let's see how the prosecution responded to the defense's motion to redepose Detective Moretti. So there was a barely onto the second page for the defense's motion. The prosecution's response is 6 pages. So they need a lot more they need a lot more space to explain why he shouldn't be redeposed than the defense needed to say why he should be redeposed. And Cindy Lou Hoot says it all started with Big Nose and Rittenhouse and Free Zachariah Anderson, now Melly. I'm not really getting behind the Free Melly thing. I'm getting behind let's just have a fucking fair trial to start with. Let's get that far. Love you, Legal Vices. You too, Cindy Lou Hoot. Let's just stick with have a fair trial for right now. Then we'll worry about free this, that, or the other person, depending on how it turns out. All right, let's bring up the state's response. State's response. Embiggen. One more. Yeah, we can go one more. State's response to defendant's motion to redepose Detective Mark Moretti. The same little boilerplate wording here at the beginning. Comes now the state of Florida by and through the undersigned assistant state attorney and submits this memorandum of law in opposition to the defendant's motion to redepose Detective Mark Moretti. First, the defendant's motion is legally insufficient. It fails to provide any legal basis as to why redeposition should be permitted. It merely is merely conclusory and fails to demonstrate the good cause as required under Federal Rules of Criminal Procedure 3.220H infra. The defendant wishes to redepose Detective Moretti in regards to cell tower location information mapping and data generated from health records. This information was available and had been disclosed prior to his first deposition. That the defense failed to inquire upon those issues is not the responsibility of the state. See this particular case here. J.S.'s hearing on his motion to redepose the victim, the state informed the trial court that at the victim's first deposition, the victim was already asked and she answered questions about whether, among other things, touched her breasts, buttocks, or genitals, or the clothing covering their lawyer attended and participated in this deposition. And to defense counsel's credit, admitted that these were areas that I should have covered and I didn't. Given the particular facts of this case, so that was a previous case. That was a previous case where it was a request for redeposition was denied because the defense counsel admitted that he should have done it but didn't. So now they're comparing it with this case. Given the particular facts of this case, defense counsel's oversight is not the sort of good cause shown to subject the victim to a second deposition. The trial court was well within its direction to deny the motion. So that they're saying that he said, "Oh, I should have done it and I didn't." That was not good enough to allow for a redeposition. So, they've stated two cases. Sorry, before they compare it with this case, they're going to offer another case. This Holland v. State. Holland claims that the trial court abused its discretion in denying Holland's motion to redepose certain witnesses. To support this argument, Holland points out that the defense attorney during the retrial was not the same attorney that handled the initial trial. The court properly denied the motion as it did not constitute good cause. So they're saying here, even changing to a new defense lawyer isn't enough of a good reason to allow a second deposition. So now they're going to compare those two cases to this case. The defendant makes a vague allegation in regards to discrepancies between his testimony and the actual evidence, but offers no specific allegation, example, or offer of proof. This also does not constitute good cause. Can't be good cause is what they're saying because he didn't say why there was a discrepancy. He didn't say what the correct answer was or what where they thought he was wrong. They just said there was discrepancies. The defendant also contends that Detective Moretti solicited BSO deputy to commit perjury. However, Detective Moretti is not currently under investigation by any agency for alleged misconduct in 2022, and the Miramar Police Department Internal Affairs investigation did not substantiate the complaint. I think that's now the cell phone tower stuff. I'm kind of leaning towards the prosecution, the state, with regards to those arguments. You should have asked the shit. You didn't ask the shit. You don't get to re-ask the shit. That's kind of how I feel about that. But this BS here, Detective Moretti isn't currently under investigation. The internal affairs didn't find anything to substantiate the complaint. So therefore you shouldn't be able to ask him about it. I don't think so. I don't agree with that. Further, any testimony in regards to any attempt to solicit perjury is not relevant to the case at hand. We'll talk about that in a second. I know where they're going with this argument. Detective Moretti's alleged conduct in a separate criminal investigation in 2022 is unrelated to the defendant's 2018 case. The 2022 investigation is dealing with the witness tampering investigation, investigating whether Melly and Bortland tampered with a witness, to the ex-girlfriend, to try to get her not to testify. So they wanted YNW Melly mother's cell phone so they could find and look for evidence regarding this other issue of witness tampering. So they're saying it has nothing to do with this case. I don't think it has any direct relation to the case, but it certainly goes to the credibility of the witness. If he's soliciting people to commit perjury, and if he's executing illegal search warrants in one case, that certainly calls into question his credibility in other cases, I believe. So saying general acts of misconduct are inadmissible as impeachment evidence. General acts. This is kind of a specific act, I think. See Bain v. State, Washington v. State. So let's see what this says. Trial court properly excluded evidence that the state witness had been dismissed from sheriff's department for writing bad checks and had dealt in stolen firearms. Okay, so saying he's a bad police officer, because he wrote bad checks and sold illegal firearms. Now, in this case, if they said, "Oh, Detective Moretti, he writes bad checks," okay, I don't think that really goes to his credibility in this case. But when his credibility is directly linked to his job as a police officer, I think there's a little more weight than the prosecution's letting on here. Jackson v. State. In previous trials, the detective had tried to obtain a search warrant after the fact and had counseled witnesses to lie on the stand. Appellant asserts that the police department hearing on these violations led to the detective's demotion and temporary suspension from the department. The record also reflects that the detective admitted he had been suspended for 3 days, but denied he had anything to do with suborning perjury. And subsequently, he had been promoted to captain in the department. Yes, you commit perjury, you get promoted to captain. In previous trials, the detective had tried to obtain a search warrant after the fact and had counseled witnesses to lie on the stand. Okay, there we go. There's a little cut and paste problem. They've cut and pasted the same thing twice. I hate when they do that. The record also reflects that he had been promoted to captain of the department. We find no error in granting the motion in limine. So in that case, they said he wasn't allowed to be redeposed in that case. So now let's look at this case here. Generally, Florida law precludes the use of specific acts of misconduct. Generally, it precludes the use of specific acts of misconduct by police officers as a method of impeachment. Generally. The Supreme Court of Florida has held that an internal reprimand is not sufficient for impeachment purposes under FS section 90.6101, which requires a conviction for a crime of dishonesty or false statement. Okay, so they're saying that anything short of a conviction wouldn't be enough to trigger a redeposition. Evidence of an internal affairs investigation is not admissible unless it is directly related to the case being tried, i.e. conduct stemming from the actual investigation everywhere. See State v. Bullard, holding that an internal affairs investigation finding that an officer made false statements to the public and was suspended for 3 days is not admissible or relevant because the conduct was completely unrelated to the defendant's case and therefore not material, relevant, or admissible. Let's see where they're going with that. I know where they're going with it, and I don't know if I like it or not. Let's see. Even if a state witness is currently under investigation, the investigation must not be too remote in time and must still be related to the case at hand to be relevant. See Breedlove v. State. In Breedlove, testifying officers were under internal affairs investigations for misconduct, including possible crimes unrelated to the actual case and trial. The Florida Supreme Court held that such evidence is not relevant, however, when the conduct and investigations are totally unrelated to the case at bar. I don't think they're totally unrelated in this case. They're totally different cases, but they're related because it's dealing with the same people, the same incident. I think, a prior investigation that is remote in time is not relevant. The defendant cites no legal authority for the admissibility of such evidence. To the contrary, the case law is in overabundance that this prospective testimony is in fact inadmissible. This matter is very factually similar to Jackson, which was determined not to satisfy the requirements of admissible evidence. Now, because the information demanded by the defendant is legally inadmissible and irrelevant based on case law and statutes, as noted above, there is no legal basis to redepose the witness either. Further, it is anticipated that the defendant seeks this deposition in order to potentially impeach Detective Moretti. Yes, that's really not a big mystery. That's exactly why they want to do it. They want to redepose him to impeach him. This is what is known as collateral impeachment. I bet they're going to tell us you can't do this. This is what is known as collateral impeachment. An issue is collateral for purposes of impeachment by contradiction, if it cannot be introduced for any other reason than contradiction. Okay. Griffin v. State. 2 types of evidence pass this test. facts relevant to a particular issue, and facts which discredit a witness by pointing out the witness's bias, corruption, or lack of competency. All right. So everything we've argued about here at the beginning of this motion, they're saying even if it's not, the defense is alluding to, the prosecution's picking up on here, even if it's not admissible for these other reasons, if you only allow this witness testimony for the purposes of contradicting him, then it must pass this test. It must be relevant to a particular issue, or facts which discredit a witness by pointing out bias, corruption, competency. Excuse me. That's where you got the corruption argument. They're saying this shows corruption. The defense was trying to make this point. They were trying to say it does meet this test and it should be allowed in because it shows the witness's corruption. It shows he was corrupt because he's soliciting perjury. He's doing all these other things. And so that's why they want this in. This evidence was not relevant to any issue in the case as it did not reflect on defendant's guilt or innocence. That's in a different case. Anderson v. State. In this case, they do not amount to either. The bias, corruption, or lack of competency must be in regards to material issues at trial here, which they are not. Soliciting perjury, yeah, it seems a little material. At trial, the victim testifies that his house had been burglarized. This is the other case, the Anderson v. State. At trial, the victim testified that his house had been burglarized, firearms stolen, and that Lawson had pawned one of the guns. Lawson testified he purchased some of the guns from the victim. In addition, he testified that his wife, now ex-wife, was the victim, and the victim were involved in a relationship and were so biased against him. On cross-examination, the state asked Lawson about his alleged drinking problem, his alleged theft of money at the victim's birthday party, his placement of an advertisement in the local paper disparaging his ex-wife. Who takes out an advertisement in the paper to disparage their ex-wife? His failure to work and his lifestyle of living from his wife's income. Lawson denied all the accusations leveled during the state's cross-examination. The admission of that testimony requires reversal for two reasons. First, it's evidence of a crime not charged, and second, it constitutes evidence of impeachment on a collateral matter. Okay. In this other case, Strasser v. Yalamanchi, the proffered evidence in this case clearly addressed a collateral matter specifically, whether Parnell gave untruthful deposition testimony in another case. Nor did the evidence demonstrate bias, corruption, or lack of competency on the part of Parnell. Cause for the accident not relevant. So they're just going through. Okay. I have something to say here. Let's get to this last little bit. What they're doing here is they're throwing out just a bunch of cases, and they're summarizing the cases as to why those cases were not allowed to redepose witnesses. They're giving a gigantic laundry list of all these different cases where the person was not allowed to be redeposed. I have thoughts on that if I can remember to read them here. To give them here in about a half a page. Further, the evidence remains inadmissible if the prejudice outweighs the probative value. Even if the impeaching evidence has some relevancy, they say in Caruso v. State, the evidence is subject to exclusion if its probative value is substantially outweighed by the danger of confusing the issues, unfair prejudice, misleading the jury, or needless presentation of cumulative evidence. Lee versus State says, however, in this Lee versus State case, the court held that, however, as in the case of other irrelevant evidence of bias may be inadmissible when it creates a danger of unfair prejudice, confuses the issues, misleading the jury, or results in a needless presentation of cumulative evidence. Thus, for example, should the trial court find that the form of a proffered question is designed to elicit bias, which may be too remote in time from the incident in question. A bunch of other cases are listed here. Then he might properly conclude that the probative value of an answer, blah, blah, blah. Okay, let's skip all that shit. Here we go. Wherefore, now let's get back to this case here at hand, and then we'll talk about the flaw with this as I see it. Wherefore, the state asks this county to deny defendant's motion to redepose Detective Mark Moretti. The information sought was previously known in regards to the cell phone information. The defense provides no basis for inconsistent evidence, and it is not Brady violation, not turning over the evidence, because it's collateral, not exculpatory, and it's not admissible impeachment evidence, because it is an inadmissible single bad act character evidence, not a conviction or even a sustained finding, and it may not be used for impeachment pursuant to black letter law. I hear why I certified this. All right, that was a whole bunch of confusing statements, other court cases and whatnot. Now I'll tell you where I have the problem with that. In the defendant's motion to redepose Moretti, they said, we learned all of this new information. We need to talk to him about it. That's an exception. We need to be allowed to talk to him to present our case. The argument the prosecution made was, well, they didn't give any case law. They just cited a bunch of facts and then said, therefore, we need to depose the guy. But there was no legal basis for it. Now, I think in reading through that, the prosecution did the exact opposite of that. They laid out 5 pages of case law. This case held this. This case allows the evidence under these circumstances. This case prohibits the evidence under these circumstances. This case provides the exception. That case explains and then, so therefore, this case doesn't fit those. They did the exact opposite, and they presented all of the case law, but I don't think they explained why this case fits those particular case law issues that they brought up. So we've got the one side, the defense, giving all of the facts and reasons without the case law. And then you have the prosecution just citing a bunch of case law without tying it, relating it to, and explaining how this case fits within the framework of those cases. This is going to be an interesting one for the judge to decide. It was expected that he would give his ruling last Thursday. We're a week away and he still hasn't decided this. So I think it'll be interesting. I personally think that they need to redepose Detective Moretti. I think they should be allowed to do it. I think there's a serious enough issue here. The cell tower stuff, I would say probably not. So, okay, you can redepose him, not about the cell phone stuff, only about these other things. I'll let you know what the judge decides. But what do you guys think here? Very quickly, one in chat, if you think they should be allowed to take another deposition of Detective Moretti, or 2, you think they should not be allowed to talk to him again. One's in chat for a new deposition. 2 for you had your chance, you don't get another one. Let's see. Let's take our Insta poll here. I'm ready to speed the slammer, says Jennifer. Lots of ones. Where's our 69s and 420s and all those other things there? I'm sure they're coming. So far it's been unanimous 1. Oh, there's a 2. Valhalla waits as just being a contrarian. 69. There you go. Jeremiah Jordan does not disappoint. 420. There you go. He's got both bases covered. There you go. Because I mentioned it. Stippling Vaughn brings us a 2. I wonder if that's a real 2 or just a I'm being contrarian 2. Lucentile says they have to be able to talk to him again so they can compare his new statement to whatever the alternate Moretti the state produces. I think they should be allowed to redepose it. Should all evidence be allowed to be brought forward? No, I don't think so. I think the rules of evidence are important. Some evidence, just shouldn't be allowed. I don't think you should just allow every single piece of evidence in. Leafy Fifi Foo says, I wonder what word you were going with then calling him a contrarian. No, I was going to say contradiction. But then I corrected myself to contrarian. I wasn't going to call him a cunt, if that's what you were wondering. Because if he was, I would just call him that. So it looks like it's pretty unanimous here. 42. Well, Joe Choi has the answer to life, the universe, and everything. The ultimate question right there. 42 obviously is the answer. And right. We've got one more issue to talk about. This is a little different. Well, I'll let you know how the judge decides on this motion to redepose Moretti as soon as I learn. Oh, Valentino Doggy asks, would this open the door to Melly's witness tampering? Well, that's also one of these things we're going to be talking about before the actual opening arguments start. The prosecution is trying to bring in to the retrial the fact that he is being accused and charged with witness tampering, which I don't think should be in, but they're arguing it should be. So we'll talk about that. We'll talk about that when we get a chance. That'll probably be 2-3 weeks from now. But we'll get there. Hopefully by then the judge will have made a ruling, because the judge is really far behind on his rulings, because no lie, I mean, there's just motions. They're probably 20, 25 motions behind, because both sides are just fast and furiously filing motions. But now we've got an interesting problem. YNW Melly's mother. She was there at the first trial. She was there for the verdict. She's been there every day during this next round, during the jury selection process. She's been there and she's been attending, but there's a problem. Let me get the stash out of the way here. Whew. This is an interesting problem. I've never heard of anything like this before. Yes. Valentino Doggy says, okay, I have thoughts. I'll wait for you. I want to see how the court rules on that issue, and then I'll probably have thoughts too. But for now, let's look at YNW Melly's mother. Let me close this thing here. And then let's read this article here first. That's important. We don't want to share it. We just want, all right. Right. Prosecutor in YNW Melly case wanted rapper's mother banned from trial. What happened? The prosecutors, this poor guy just looks so confused. The prosecutor in YNW Melly's murder case, days into the first round of jury selection, requested that the South Florida rapper's mother be barred from sitting through the retrial. They want her booted. Prosecutor Alexandra Buckaloo, still a fresh face in Melly's case, urged Broward Circuit Court Judge John Murphy. I don't know. That's always tricky to say. Broward Circuit Court Judge John Murphy last week to ban Jamie King, Melly's mother, from having contact with jurors and entering the courthouse unless as a witness. They don't want her anywhere near during the jury selection. They don't want her there during the trial. The only time they want her to be allowed in that courthouse is when she testifies as a witness, if she testifies. On top of that, Buckaloo asked Murphy to mandate that King, Melly's mom, stay 1,000 feet away from the building. Ooh, 1,000 feet away from the building. and allow the prosecution to conduct an inquiry of all pre-qualified jurors. So what they want is the prosecutor wants her booted out of trial, not allowed to come back anywhere near the place unless she's testifying as a witness. They want her at least 1,000 feet from the building, and they want to talk to every single witness about something. I mean, every single prospective juror about something. And we'll get into that in the motion here in just a minute, exactly what they want. Peggy Reardon asks, where is the camera? Where's Doggo Cam? That's an achievement that gets unlocked at the $100 mark, and we are exceptionally far away from that. It's very, very highly unlikely Doggo Cam will be unlocked today. We'll just have to see. But for now, it's probably unlikely. So let's get back to that. Let's get back to this motion here. But thank you for your concern. The strawberry is sleeping very peacefully over there. You can probably hear her snoring away. Right. YNW Melly's mom. The prosecutor's latest filing came after a prospective juror alleged that she saw King crying near the parking lot. A prospective juror allegedly saw King crying near the parking garage in what Buckaloo called a clear attempt to manipulate or influence potential jurors returning for attorney questioning. So they're basically saying, mom was out there bawling, trying to make the jurors feel bad for her. The juror who works for the Broward Sheriff's Office Yeah. We read that right. There's a prospective juror who works for the sheriff's office. She or he, she called the BSO legal counsel Christian Subanos and said she saw a woman wearing blue scrubs in the courtroom later, obviously crying into a tissue as jurors were exiting to the parking garage. So this prospective juror who works for the sheriff's office calls and says, she saw someone who looks like the defendant's mother fake crying into a tissue. Uh-huh. The juror also claimed King tried to make intense eye contact. What the fuck does that mean? Tried to make intense eye contact with her and was clearly trying to get her attention and speak with her eyes, according to the filing. I'm speaking with my eyes too. I just have my screen really small so you can't see it. But I'm intensely trying to communicate this bullshit with my eyes. So a prospective juror who works for the sheriff's office says that there's someone out there that looks a lot like the defendant's mother crying into a tissue and intensely trying to communicate with her eyes. Ugh. Right. Well, King, Buckaloo said, was in the courtroom on Tuesday and didn't appear to be upset or in distress during the proceedings. Instead, she was in good spirits and even giddy when she saw a coworker on the panel. When asked if he heard about the case, the potential juror coyly stated, "I'd heard of it, wink, wink, nudge, nudge." According to Buckaloo's filing, he later divulged details about his relationship with King. Despite these heightened security protocols, security concerns have not arisen regarding improper jury contact and attempted jury tampering only 2 days into the trial, Buckaloo argued. Security concerns have not arisen. Okay, so what's the problem? But King told the Miami Herald that none of that happened, adding that she was completely bewildered by the accusations. What? So you're trying to tell me that the courthouse doesn't have CCTV cameras in the parking lot, on the lawns and the door where they can just roll the tape and see if she did this? Because this is a he said, well, this is a she said. This is what the prospective juror that works for the sheriff's office said, or this is what the defendant's mother said. She's completely bewildered because none of it happened. Roll the tape. There's got to be tape there. It's all frustrating, King said. I've been in this courtroom for over 4 years. I know the rules. I've gone through this. When prosecutors argued for the ban in front of Murphy Wednesday, King said she felt like she was being bullied and was so uncomfortable that she decided to leave jury selection early. She said the only chance she gets to see her son, who doesn't have access or phone calls or visitation, is during his court appearances, and she will continue to show up and support him. I understand that the state has a job to do, but to attack me, she said, I'm at a loss for words. Well, let's go to the tape, shall we? And by tape, I mean motion. Now for this one, I've just got the mother's motion to remove Melly's mother and to question all of the pre-qualified jurors. I don't have any response from the state, and I've got the court order. So this is going to be a one-sided thing. And we're gonna look at that right now. The last little bit we touch on here today. This is a 7-page motion. We're gonna get into some nitty-gritty here. New prosecutor, new allegations against YNW Melly's mom. let's get YNW Melly's mom booted from court. Let's see where this one goes. Right. See if we can embiggen this one more. 2 more clicks. State's motion for inquiry of all pre-qualified jurors and motion for relief. Comes now the state of Florida by and through the undersigned assistant state attorney and moves the court to grant the state's motion for inquiry of all pre-qualified jurors and motion for relief and comments as follows. On October 24th, 2023, the above captioned case was set for pre-qualification of jurors. Jury panel number 4 was the first group of 100 jurors brought up to the courtroom to be pre-qualified. Those who were available based on scheduling are set to return on November 6th, 2023. So again, the first phase, they just say, who can't set aside time for this? Okay, leave. If you have the time, then come back on November 6th and we'll go through another round. And so that was 2 days. That was yesterday. Cool. Out of 100 jurors, 12 jurors are set to return. So 88 of them got the boot. 12 jurors are set to return on November 6th. Unbeknownst to the state, juror number 306 is a Broward Sheriff's Office employee. After being released as a juror, another piece of the puzzle fits in. Somebody from Broward County Sheriff's Office was a juror, and then they got booted off from being a juror, most likely because they worked for the sheriff's office. Then, and only then, only after being booted off of this high-profile case, did the sheriff's office employee call the legal counsel for the state people to inform him, Mr. Christian Tsubanos, to inform him concerning information she witnessed during her jury service. I wonder if she would have been kept on the jury if she would have called and complained. Or was it just because she got booted off, she was a little butthurt maybe, and called this in? We'll let you decide which of those particular theories you believe or whether you might have another explanation. But anyway, Juror 306 stated she witnessed a black female wearing blue scrubs sitting in the courtroom with the deputies while the jurors were being questioned. She indicated when all the jurors were leaving, she witnessed the same woman standing by the entrance doors to the courthouse on the 3rd floor, where all the jurors walk in and out of, as that is where the juror parking lot is located. Juror 306 immediately recognized the woman as the same woman she observed sitting in the courtroom during jury selection, and her attention was drawn to her due to the fact that the female was observed to be obviously crying into a tissue as the jurors walked out. Okay. Juror 306 indicated the female was by herself, appeared very upset, and was wiping her tears with a tissue. While the courthouse can be busy around standard lunch hours of 12 to 1 p.m., panel number 4 was not released until approximately 1:30 p.m. The defendant's mother Jamie King was present for jury selection on October 24th, 2023. Mrs. King was the only civilian non-juror sitting in the audience during jury selection and was wearing blue scrubs. It's like literally the only person that was sitting there that was not there for jury duty was YNW Melly's mom. It was also very apparent that Ms. King was in and out of the courtroom throughout the proceedings throughout the day. It should be noted that at no point did Ms. King appear to be upset or in distress during the proceedings. On the contrary, she appeared to be in good spirits at all times. In fact, at one point, Ms. King saw a coworker on the panel whom she discusses her son's case with. Her demeanor was giddy when she witnessed this juror walk in, and the state placed her behavior on the record. Oh, that's interesting. So she apparently did something like being called down as a contestant on The Price is Right, and hey, friend, or something. She did something that would warrant the judge going, all right, put it on the record. She's behaving like a doofus. All right. So she did whatever she did, however she responded to seeing her friend and coworker up there up there in the jury pool was so noticeable that the juror decided to mention it and place it on the record. When initially asked if anyone heard of the case or the defendant's stage name, this particular juror coyly stated he had heard of it. Coyly stated. Insinuating that he did not know much. See, this is some bullshit on the case on the part of the prosecutor. This is just some unabashed bullshit. When asked if anyone heard of the case or the defendant's stage name, what is that question? Have you heard of this case? They didn't say, have you heard of this and do you have any deep knowledge or understanding of this case? That wasn't the question. The question wasn't, do you know lots of details about this case? Do you have an in-depth knowledge of this case? The question was if anyone has heard of the case. His response was, I'd heard of the case. The fuck's the problem? You're asked, have you heard of the case? You respond, I've heard of the case. But that's coy. Even if you have he wasn't asked if he had a great amount of detail. He was asked if he'd heard of the case. He said, I've heard of the case. But he was insinuating, he was coyly insinuating he didn't know much. That's some bullshit on the prosecutor's part right there. Coyly insinuating that he didn't know much when he really did. Then ask him if he knew much. Don't ask him if he's heard of it. He says, yeah, I've heard of it. This is them trying to show that she's all sinister and needs to be booted out of the case. And there's all these other people that want to get on the jury that, they're not going to reveal how much they know. If you want to know how much they know, ask them. Just fucking ask them how much they know. I hate this sentence. I really, really hate this sentence. It was only after being brought back in after a restroom break where Mr. King could have been roaming the halls with the juror that he eventually came forward and indicated he knew the defendant's mother and elaborated on their relationship. Oh, let's throw in some speculation. First of all, he coyly answered the exact fucking question they asked. He answered the exact fucking question. Have you heard of this case? Yeah, I've heard of this case. But that's coyly insinuating he doesn't know much. But then during the break, he could have been roaming the halls with the juror. You can't just say he could have been talking to her. He could have been out. He had to be roaming the halls with her. Not even he was roaming the halls with her. He could have been roaming the halls. Nobody knows if they did or didn't. So they're using these catchwords, these words to try to paint this as some big, deep, dark, demonic thing she's doing here. Coyly. They're coy. They're insinuating. They're roaming. They're not walking. They're roaming the halls. Ugh. Ugh. The state also noted that Ms. King left the courtroom prior to the juror's dismissal during the afternoon session of jury selection on October 24th. She also walked in late while all the jurors were all in the hallway waiting to enter. So what? The state is aware that Ms. King is typically dropped off in front of the main entrance to the courthouse, which is nowhere near the juror parking garage. Joe Choi asks, who uses coily outside of novels? The throbbing, pulsating. The words like, yeah, people don't use those unless they're like in cheap novels. The state is also aware that during the prior trial, that individuals associated with the defendant loitered around the same area Ms. King positioned herself while jurors were walking freely to their vehicles. So during the previous trial, her and her minions were loitering where jurors could see them. It's apparent Ms. King positioned herself in an area that is known for where these prospective jurors would be present. It is highly inappropriate for Ms. King or any other party to place themselves in a position where their conduct could have an impact on the jury. Positioning yourself at the juror parking garage and crying is a clear attempt to manipulate or influence potential jurors returning for attorney questioning. Now, see, right there, this paragraph is enough. This paragraph is enough. It says, look, she's someplace where she wasn't anywhere near where she got dropped off. It was somewhere she had no business being. That somewhere she had no business being and wasn't near where she dropped off is also happens to be the entrance where the jurors come in and out of. And she wasn't seen crying, but suddenly she's crying when the jurors are walking by. This is improper. She shouldn't be anywhere near where the jurors are in any way they could possibly be influenced, whether she's crying genuinely or fake crying. She shouldn't be there. That's a perfect argument to make. But who coyly? Well, they're insinuating this. They're roaming the halls. That's just bullshit. Furthermore, juror 349. This is another juror. This is not 306. This is 349. Juror 349 informed the state that while walking into the courtroom and while seated in the courtroom with her fellow jurors, Ms. King made it a point to try and make intense eye contact with her. What the fuck is intense eye contact with her? What does that even mean? Ms. King made it a point to try to make intense eye contact with her. Juror 349 described this behavior as someone clearly trying to get her attention and speak with her eyes. God, that hurts to even do. I don't even know what that means. All right. Juror 349 interpreted Ms. King's behavior as a way for Ms. King to try and approach the juror later. Let me talk to you later. Oh, for fuck's sakes. Interpreted Ms. King's behavior as a way for Ms. King to try and approach the juror later. Fine, which was extremely uncomfortable. Juror 349 indicated Ms. King was seated quite close to her, and that is why she could see her while seated in the courtroom for questioning. Ms. King's behavior is nonverbal communication and is completely improper. The issue is what the state raised as a major concern at the beginning of the second trial, and that is why there are heightened security protocols in place. Despite these heightened security protocols, security concerns have now arisen regarding improper juror contact and attempted jury tampering. Only 2 days into the trial, we've used in bold letters attempted jury tampering just days after her son was charged with 7 basic counts dealing with witness tampering. That's a tampering family. The state is asking the court to conduct an inquiry of all pre-qualified jurors. So 2 of them came forward, so they want all of the jurors, all of the pre-qualified jurors to be questioned. As the court and all parties are aware that Ms. King was also in the hallway during the first day of jury selection, it was previously placed on the record by defense counsel on October 24th, 2023 that Ms. King showed up on day 1 of jury selection and was not permitted in the courtroom due to lack of seating. A trial court has discretion to determine what remedy is required when a comment is made to the jurors outside of the presence of the court. Was a comment made to the jurors outside the presence of the court? Staring intently, crying into a cloth, attempting eye communication. Was there any real communication made outside the presence of the court? Well, here's another long list of cases. In State v. Smith, the defendant's mother said, "God bless you," to 70 potential jurors assembled in the hallway, and the defendant moved to strike veneer. Just get rid of them all. I mean, just get rid of all of them. She said, "God bless you," to 70 people. They wanted the defendant moved to get rid of all 70 of them because they happened to be in the hall when she said, "God bless you." The court ruled the trial court acted appropriately by questioning the jury panel to determine who had heard the comment and whether the comment would affect their ability to be impartial. In addition to conducting the inquiry of each juror, emboldened, the court entered a written order that Smith's mother was not to have contact with the jurors, not to enter the building unless called as a witness, and not to come within 1,000 feet of the building. Oh, that's where they get this remedy they want. They got it from another case. The Florida Supreme Court held that given the magnitude and nature of this case, the trial court did not abuse its discretion in imposing the security measures that Smith contends prejudiced him. The security measures were justified based on the allegations in the indictment and the testimony at trial. All right. Well, in Street v. State, when passing the jury in a hallway, someone uttered the word "guilty." Upon learning the comment, the judge investigated the incident and individually questioned the jurors known to have heard the comment. These jurors stated that the comment had not affected their ability to be fair and impartial. The judge inquired of the remaining jurors collectively whether they knew of the incident, and none of them indicated any knowledge of it. The court found that given the isolated nature of the incident, the action taken by the judge was sufficient to determine whether the jurors were improperly influenced by the comments. Another case, trial judge adequately conducted individual voir dire of jurors to determine whether they were impartially influenced by witness jury foreman embracing the victim's mother. Yipes, don't do that. In addition to conducting an inquiry as to all jurors returning for further voir dire questioning, the state requests. So we want to question all jurors that are returning for voir dire, and the court should enter a written order that Ms. King is not to have contact with the jurors, not to enter the building unless called as a witness, and not to come in within 1,000 feet of the building. Should the court not issue such an order, the state requests, at the very least, that Ms. King be prevented from attending any further days of jury selection. They're saying they don't want her anywhere involved in this. They don't want her having any contact with the jurors. They don't want her to be allowed to come to trial unless she's a witness. They don't want her to be within 1,000 feet of the building, but at least don't let her come back during jury selection. If you're not going to do all that, just at least don't let her come back for jury selection. Furthermore, should Ms. King feel the need to enter the courthouse or parking structures, the state requests that she be required to check in with the Broward Sheriff's Office. Additionally, an admonishment from the court is requested, as any further inappropriate conduct would also be considered contempt of court. Ms. King has already gone through the trial process once and is aware of the court's instructions regarding behavior around jurors. And yet, she still found a need to stand in the exact area jurors park and cry as they walked by. The appearance of impropriety alone requires a hearing, and due to her behavior, the requested sanction should be imposed. The court was made aware that 6 individuals on behalf of the defendant will be appearing in court for jury selection on October 25th, 2023. The last row of the gallery has been reserved for them, and the state requested an empty buffer row between the defendant's family and friends and the potential jurors due to concerns the state has expressed regarding the sanctity of the jury selection process. Due to additional members attending jury selection on behalf of the defendant, the state requests all parties be instructed as to appropriate behavior in and out of the courtroom. Furthermore, the state requests that all individuals entering the courtroom must check in with a valid identification. State v. Smith. The state also requests no individuals be allowed to enter and exit the courtroom while jurors are present. And once jurors are released, the state requests all parties in the courtroom wait until the jurors have vacated the building. Additionally, the state seeks to have any parties needing to use the restroom while jurors are present in the hallways prohibited from using the facilities on the 4th floor. The integrity of our judicial system has been compromised, and it is imperative that the court take further measures to ensure the safety of the jurors as well as the case. Intentionally left blank. Wherefore, I promise everything is true. So that is the motion. And the order is the order on state's motion for inquiry for all pre-qualified jurors. This is the state's order, the judge's order. The cause came before the court on the state's motion for inquiring of all pre-qualified jurors and motion for relief filed on October 25th, 2023. The court held a hearing on the motion on October 25th, 2023. Having considered the state's motion, arguments of counsel, the court file, applicable law, and otherwise being fully advised, the court finds as follows. The state alleges the defendant's mother, Jamie King, had improper contact with certain pre-qualified jurors, and asks this court to institute measures to protect prospective jurors from further influence, relying on State v. Smith. The court hereby orders Ms. King to stay away from all prospective jurors and from any areas where prospective jurors are likely to be present at any given time. Ms. King is ordered not to have any contact with prospective jurors, whether verbal or nonverbal. Ms. King agreed in open court to comply with the above directions. Well, there you go. There's the court's ruling. She's to stay away from all the jurors and from any areas where they're likely to be present at any given time. Not to have contact with jurors, whether verbal or through intense eye communications. And she agreed that that would be appropriate. So sling that down there in chat. What do y'all think about that? What do y'all think of the judge's ruling there? I think it's an interesting ruling. I mean, I think it's interesting they want the mother removed anyway. I didn't like. I have lots of problems with everything because I'm a problem child. I guess I just don't. I don't like all the the hyperbole, all of these statements that are thrown in there. Lurking, roaming the hallways. Yeah, but anyway, he ordered her to avoid the jurors and to not have any further contact. So I guess she still gets to come to the jury selection process. She still gets to sit in trial. They're not going to question all of the witnesses, but she's just not going to have any more contact with them. So she gets to be there. Apparently, she gets to sit through this. Yes, it appears she is allowed in the courtroom. What have I done here? Right, yeah. So the eyeballs is enough to punish a civilian, but admitting to lying is not enough to punish the state. Yeah, kind of unfair. Well, she's not being barred from the courtroom. She's allowed to sit there during the jury selection. She's allowed to sit there during trial. She's just not allowed to interact in any way with the prospective jurors. I think it's kind of fair. Because, it is kind of a shady thing to say she's dropped off at this door, but she happens to be crying into tissue at, in the other side of the courthouse near the door where the jurors walk in and out of. Was she probably doing this? Yeah, probably. I think the judge could have been much more stern with her and given her much more of a punishment than he did. I think it's pretty fair. They feel like nobody should have been talking to any of the jurors anyway, so it's just putting it in writing. Exactly. That's kind of, you know, like, just look, don't do that again. That's your one chance. I get the pesky feeling they're bullying this woman. First she was manhandled by Moretti, and now this. You may be onto something there. I guess, but the judge has ruled. So we'll see how the judge rules on this, on the issue of whether or not to allow them to redepose Moretti. And I'll let you know that as soon as he makes a decision on that. Looking at what we're going to be covering next Melly update, which will probably be next Tuesday. The witness tampering. Oh, no. Next time was going to be, because people have been asking, why was only prosecutor Bradley, Christine Bradley, why was she the only one that was thrown off the case? Why weren't the superiors in there also? Why wasn't the whole office recused from the case? Well, next time we'll read these orders. We'll read the order granting the request that prosecutor Bradley be recused. So we'll look at the court's reasons why she was booted off the case. And we'll also look at the order denying the request to recuse the entire prosecutor's office. So we'll look at that. So we'll get the court's reason why everybody in the prosecutor's office wasn't excused. And also the court's reasoning for not allowing the defense to call the 3 superiors in the prosecutor's office as witnesses. We'll look at those 3 motions next time. After that, we'll start looking at the motions and the allegations regarding the witness tampering. Now, something that I think somebody mentioned in chat, there was the most recent motion that's been filed, was filed a couple of days ago. It was a motion to strike all of the jurors that have in-depth knowledge of the case. Something more than just hearing it or hearing references to the first trial. People that have a good deal of knowledge about the case. They want all of those people booted off. There was a motion filed for that just the other day. We'll look at that somewhere down the line once the defense gets their rebuttal, their reply, and maybe once we get the ruling on that by the judge. We'll keep you posted on how that one goes. So, ladies and germs, thank you so much for being here. This brings us up to date on this part of the YNW Melly trial. The motion to redepose Detective Moretti. The judge hasn't ruled on that yet. And the request to have Melly's mother booted from the courtroom was essentially denied. She was given a stern warning, put on the record, and she's agreed she wouldn't do anything that the judge just told her not to do. There we go. Join me tomorrow for the opening statements in the Texas bicycle love triangle, we'll call it. It's a bicycle love triangle murder. The court doesn't allow the cameras in the courtroom during the trial itself. The judge said that only opening statements, closing arguments, and the verdict will be streamed, broadcast. But I want to look at the opening statements because I watched them with Hayden, Aussie Overlord, live. The prosecutor did a great job. The defense, not so much. And I want you to see a really bad defense opening, not a short one, not like the Chandler Halderson defense opening, which was just kind of, hey, I got nothing. Keep an open mind. Yeah, see ya. That wasn't a bad opening. Sometimes that's all you got. This Texas bicycle love triangle murder trial, that was just a really bad defense opening. And we'll break it down. We'll talk about it tomorrow. So join me for that. Thursday will be Chandler Remington and I doing our OJ stream. We're winding down OJ. We've probably got another 4 weeks of OJ. Then we're going to do a new trial. We're going to start streaming an entire new trial And by new trial, I mean an old trial, but one that's not OJ. We'll give you more details on that. The whole trial took, I think, 21 days or something. So it's a doable old trial. It's a historical trial that also involves Barry Scheck. Barry Scheck of course, OJ fame. He was the defense lawyer for this particular case. So we'll get more Barry Scheck. And we'll let you know Friday when it happens. But before we go, I do have to say we have an unboxing here to do. Joe Choi sent a box of stuff. It's at the office. I'll have to remember to bring it home. There's some yummy stuff in there, some of which didn't survive the day today. But Joe Choi's unboxing will happen. It finally got delivered to my office, and I've learned some more things about shipping stuff. So tomorrow we'll do a little unboxing there with Joe Choi. Thank you very much for your box.
Phrasing.
Thank you, Joe Choi, for sending a package. That just didn't sound very good, did it? All right. On that note, we will end. Thank you, mods, for being here. Thank you for everything y'all do. Thank you, chat, for your support. Join us tomorrow. No, we'll do the unboxing. I'm sorry, on Thursday. Tomorrow we'll be doing this other thing, the Texas bicycle love triangle murder. We'll do the unboxing Thursday on OJ. We'll see how much of the yummy goodness is still around by Thursday. So, folks, no, it doesn't have Marmite in it. I wish it did, but it didn't. All right. That's what we've got. Join us tomorrow. Thank you for your support, chat. Let's unleash Doggo Cam tomorrow. It's been a while. Strawberry's getting lonely over there. Have a great night. I think I'm going to send you on over to Megan Fox now. So let me get that all geared up. We need our Mergen Ferks here. We have to go into the YouTube studio. It's closing. It's closing arguments for the taking care of Maya case. Let's see here. Go to YouTube studio. Go to live, which we're looking at here. Live. And while I'm doing this, make sure that there was 227 of you here. Hit that like if you hit the like button if you haven't, and please, if you have not subscribed, consider giving me your subscription. Click on that subscribe button. Click on the notification button, and stay tuned for all the Melly you can handle. We're gonna go gavel to gavel once it starts. In the meantime, we're going to be catching you up on the motions and things like we did today to keep it fresh in your mind, to keep you updated, and to keep you in the loop, as they say. All right, we are now set up to do the Taking Care of Maya stream from Megan Fox. All right, folks, take care. Thanks for being here. We'll catch you tomorrow. And until then, whatever you do, just make sure you enjoy your legal vices. Lawrax out.